Well, good afternoon, everyone. Thank you for joining me today. Thank you for finding your way here. It's no mean feat. Over the weekend, I was emailing the conference organizers in desperation saying, my panelists have abandoned me. This is going to be a TED talk, but actually I'm going to call it a Lear sermon because I'm actually sitting on an altar. This is the closest that I'm going to get to delivering a sermon. So this might sound like a bit of a monologue, but I know we've got some great people and industry experts in the room, so I hope that I can give you some food for thought, and that perhaps towards the end of this session we can actually have a conversation rather than just me lecturing at you. I'm going to spend at least half of the time not talking about the law, because I think it's important that we have a step back and think about context and the strange times that we live in today. But I will eventually get to competition law and the theme of innovation, and I would appreciate sort of your interactions and your reflections, if time permits, towards the end. So the theme is the role of competition law in protecting and promoting innovation. I think we can all agree that that's an important goal. The question is whether today, and given this sense of direction, are we getting the balance right? Is it time to stop, reflect, and perhaps recalibrate? I'm paraphrasing from a speech by the Director General of DG Comp last week, Olivier Garçon, who said, innovation is key. If we don't innovate in Europe, we won't make it. We'll become subcontractors. And I totally agree with him. And I'm really also impressed by the level of ambition and the sheer amount of initiatives ongoing at EU level to help ensure that Europe actually does better in the innovation race. The scale of the challenges that we face has galvanized the EU institutions into action on many fronts. And there's a level of activity that I actually haven't seen in my 30 years in Brussels. So I want to spend a few minutes just reflecting on the scale and pace of innovation that we need in order to tackle the challenges that we face, and then to ask whether EU competition law and policy are striking the right balance. In June of this year, the European Round Table of Industrialists that represent about 60 multinationals of European parentage published a European competitiveness benchmark report. And I'm going to throw up some slides. You may not be able to see it from where you're sitting, but I would recommend that you take a look at that report, which is publicly available, and take a closer look at some of the statistics that make for very somber reading. In the last 15 years, Europe's share of the top Fortune Global 500 companies has been cut by 50%. R&D spend as a percentage of GDP is at 2.1%, behind China, the US, and Korea, that comes in at an astonishing 4.6%. We're doing slightly better in terms of industrial R&D investment. The US is a clear front runner. The EU is about to be overtaken by China. The EU also lags behind the US and China in terms of venture capital spend on supporting startups and early stage competitiveness. It lags behind on the number of unicorns it incubates in investments in artificial intelligence, robots, sensors, IT, hardware. And we're also behind in the rollout of 5G. Robust 5G infrastructure and the technologies that it enables are necessary to turbocharge corporate innovation. 5G is key to Europe's competitiveness, and many of these findings are validated by the European Commission's own Digital Economy and Society Index that was published also in the summer. It also recognizes that full deployment of 5G connectivity infrastructure is urgent. It notes that the adoption of key digital technologies by businesses in Europe remains low. The Nordics, the Netherlands are front runners in the EU, but even there, the uptake of digital technologies such as artificial intelligence and big data remains below 30%, well below the 75% target set out in the Commission's ambitious Digital Decade 2030 plans. Another barometer, the EU Innovation Scoreboard, recognizes that in global terms, The EU's doing better than the BRICS economies, but we're doing worse than Australia, Canada, Japan, South Korea, and the US, and those gaps are getting worse. And our increased performance lead over China is shrinking. So the Commission itself has recognized that our gap in innovation performance, mirrored with the downturns in economic growth, et cetera, is actually weakening the performance of the EU innovation ecosystem as a whole, undermining cohesion, and as we head into recession and energy crisis and inflation, we are in trouble. So what are the root causes of this inequity? I'm not going to go there yet. A key factor holding Europe back is the lack of depth in European capital markets. For many smaller innovators in Europe, traditional bank loans are the main source of short-term finance, and costs related to external equity funding are not tax deductible. The EU lacks large venture capital funds. EU pension funds and insurance companies account for only 12.7% of venture capital funds in the EU. Venture capital markets are fragmented, narrow, supporting fewer and smaller late-stage investment rounds in Europe. And at the same time, IPOs play a relatively minor role. An undersized IPO market limits sources of equity funding, and that in turn limits exit routes for venture capital and private equity investors. 5% of the total divestment in 2020 took place through IPOs in the EU, and the figure in the United States was 30%. So these factors have pushed European companies to relocate through overseas listings and exits through trade sales. That is the harsh reality. Rather than looking at it from big companies, big tech, big pharma buying up small to kill off innovation, I think we need to understand the drivers of the market and the inadequacies of the capital markets in Europe that are leading to those sorts of exits. So turning to look at the pharma sector for a moment, that's an area where Europe is also lagging sadly behind. A recent report, you may have read about it in The Economist, from the Alliance for Regenerative Medicines, says that since 2018, in the field of gene and cell therapies, where there are going to be many really breakthrough therapies evolving, there are 566 developers active in the United States, 361 active in China, 134 in Europe, a fall of 6% over the last couple of years. Clinical trial data reflect that, with just 10 clinical trials going on in Europe in gene and cell therapy compared to 77 in the United States. According to IQVIA, there is no crisis in innovation in the pharmaceutical sector. Products in the pipeline have increased by a whopping 40% since 2015. Again, the US accounts for 40% of total investment. Europe is losing out. Our share of early-stage R&D has declined by 10%, whereas China's share has increased by 10%. And the complexities of the regulatory environment across the internal market also make Europe a difficult place to innovate, especially in the pharmaceutical sector. We have highly fragmented systems. Companies have to grapple with a wide array of regulation that they don't find elsewhere. Just to take one example, Europe's treatment of GMOs in cutting-edge gene therapies that use modified viruses to deliver their genetic payload means that companies have to go through multiple divergent national systems that just make life that much more difficult. And we shouldn't forget the investment burden and the failure rate of new drug development that are both high. Small biotechs often have novel science spun off from academia and research, but they don't have the funds and resources to do it alone. Just take a look at CureVac. At one point, it was the leader, coming to market first, we all thought, with the COVID vaccine. And despite very significant government funding from Germany, they simply weren't successful in the end. BioNTech's vaccine was developed from mRNA technology that was repurposed from other therapeutic targets, and without Pfizer, they wouldn't have been on the market so quickly. So there are many opportunities in brief. The science is moving fast, the future is exciting. We need to do everything that we can to stimulate and support innovation, to deliver better functioning digital and healthcare systems that deliver better solutions to patients and to our societies in Europe and beyond. And these factors have been acknowledged. I was reading recently the Commission's bold new European innovation agenda that they published over the summer, and it seeks to position Europe really as a leading player on the global innovation scene. To quote the press release, the plan is to position Europe as the place where deep tech innovation thrives and creates breakthroughs across the continent that will inspire the world, no less. Europe wants to reinforce its central role in shaping the green and digital transitions right across the economy. They've set up a new European Innovation Council that is designed with a special fund to become the largest deep tech investor in Europe, leveraging a public budget of 10 billion euros, hopefully to encourage an additional 30 to 50 billion euros investment from the private sector. Plans there include allowing innovators to experiment with new ideas through so-called regulatory sandboxes that will allow trials of innovative products and technologies that would not otherwise be fully compliant with the complex regulations that we've got. Now, it's interesting that that idea of regulatory sandboxes also came up in the ERT report on European competitiveness. And that report also states that while rules to ensure fair competition are important, they should not be overly burdensome. Europe's public sector should become more aware of the risks and weight of regulatory overload. We need greater coherence in policy making and greater ambition to avoid siloed thinking. I promise I'm going to get to the competition rules in just a minute, but I want to pause first on this notion of regulatory overload. There's a raft of measures coming that will make companies placing products on the EU market responsible for sustainability due diligence across their upstream and downstream supply chains. The goals are completely laudable, but the complexity is mind-blowing. The new EU foreign subsidies regime will require all companies bidding for large public tenders to disclose not only the financial contributions that they've received from any non-EU state, directly or indirectly, over the last 3 years, but also financial contributions that their main suppliers and subcontractors have received from any third country state over the last 3 years. The review of the EU pharmaceutical legislation that's ongoing is proposing to withdraw 2 years' worth of existing regulatory data protection and to allow manufacturers to earn back that regulatory protection if they put their new medicines on 27 EU markets within 2 years of product authorization. That proposal takes away an existing right. It doesn't address the real problem of member state unwillingness or inability to pay, but it also disproportionately affects small and medium-sized biotech companies that simply do not have the resources to navigate the complex pricing and reimbursement processes in 27 member states, let alone within 2 years. So, the picture, to take a little bit of a shortcut, is of a rule book that just keeps growing, piling layer over layer over layer to fend off and to adapt and to try and absorb the profound challenges that our economies and that our societies are facing. So what does this mean for competition policy? Well, the European Commission has embarked on a thorough revision of all the major EU competition law instruments: merger control, antitrust, and state aid. It's recently issued a number of major studies designed to look at how the rules have worked in practice and whether they're fit for purpose. In November last year, the Commission published a communication on a competition policy fit for future challenges. Those challenges range from recovering from the pandemic, whilst enabling European industries to strengthen their resilience and lead the twin green and digital transitions. Those challenges loom larger today than they did just a year ago. And the Commission has rightly recognized that an effective and well-calibrated competition policy is key to this agenda that will require extraordinary public and private investments, innovation, and a well-functioning internal market. So since the theme of this session is innovation, I'm going to tackle two subjects: the revision of the proposed R&D block exemption and merger control as it relates to innovation. Let's turn to the R&D block exemption. I strongly believe that clear and simple competition guidelines that encourage collaborative R&D have a very important role to play in promoting the EU as an investment-friendly destination and in tackling the big health and climate challenges that have to be front of mind. But let's face it, the current rules are from a bygone era. They're at least 20 years old. They are far too rigid. They are no longer fit for purpose. They contain complex 7-year duration rules tied to 25% market share thresholds. They require that parties carrying out R&D as a commercial service be entitled to pre-existing know-how and to the final results of paid-for research for the purposes of future research. They prohibit parties from agreeing to limit output or agree prices unless they jointly exploit the results through a joint organization or jointly entrust exploitation to a third party. All difficult hurdles in practice. No other advanced economy has such strictures around collaborative R&D agreements. And in its ongoing review, there's no sign of the Commission opening any of this up. Instead, it's going to add to the complexity with its new 3+1 rule. So today, the R&D block exemption broadly applies to R&D agreements that aim to develop new demand, new products, rather than improving on existing products. They treat those pre-product research collaborations as agreements between non-competitors, mainly on the basis that there's no product market on which they can calculate market shares. The 3+1 rule will say that we'll no longer treat you as non-competitors unless, where the parties compete on innovation, they can demonstrate that there are at least 3 independent, competing, and comparable R&D efforts in existence. And that will require the parties to satisfy themselves that the 3 other R&D poles are pursuing substantially the same aim or objective, and that those third parties are already engaged in the R&D efforts or are likely to be able to independently engage in such efforts. And relevant to this assessment, we're told, are factors such as the third party's access to relevant financial and human resources, the number of full-time equivalents they have in the lab, their intellectual property rights, know-how, other specialized assets, or previous R&D efforts. It's obvious that this new rule would create significant complexity. In most sectors of the economy, it cannot be assumed that that information is available with any degree of accuracy. But more troubling, this 3+1 rule assumes that there is inevitably going to be some dampening of competition that would otherwise occur. The draft rules don't provide any real explanation of what's behind this, other than vague warnings that innovation may be restricted even by a pure R&D agreement. It is feared that 2 or more companies engaged in R&D for a new product could restrict competition by cooperating instead of developing their new product separately. When you look at the scale of innovation, the failure rate, the amount of investment, the risk of that investment, the lack of the depth in capital markets to fund that investment, what are we doing with competition rules that say our starting point is that we're going to be suspicious of any agreement that might improve basic research because it might stop some product in 15 years' time, maybe making it to the market. So let me take a hypothetical example. Imagine two competitors in innovation that come together and make significant, very high-risk investments that ultimately lead to the development of a miracle cure for Alzheimer's years earlier than would otherwise have been the case. Imagine that there were no competing R&D efforts of a comparable nature at that time. The result is to be celebrated, even if it confers a monopoly pricing power on the parties for a period. The size of the prize will incentivize others to quickly catch up. And that is exactly what we saw with the race to provide COVID vaccines at the height of the pandemic. Why in Europe, uniquely, should we be concerned to ensure that parties to an early stage R&D agreement face a competitive constraint from multiple identified competing R&D efforts? Well, I'm going to tell you why, because I think the explanation is relatively straightforward. It's because of a technocratic concern that the current R&D block exemption that views this as competition between non-competitors is out of sync with the stricter approach to innovation theories of harm that the Commission has taken in the Dow DuPont case, in the specificities of R&D in the global agricultural sector. I think it's time to recalibrate, really. It's disproportionate to impose a significant administrative burden on the entire economy in relation to collaborative R&D efforts that often involve smaller entities with exciting science but few resources, as the price to pay for the legal certainty of a block exemption safe harbor that even today isn't terribly useful. The public consultation on this new 3+1 rule was overwhelmingly disliked. And last week, DG Competition held a virtual workshop on the topic that only confirmed the lack of support for this course of direction. So it's very much to be hoped that the Commission revisits much more fundamentally the R&D rules so that they are future-proof and no longer anchored in a much simpler pre-digital world, and moves away from the suspicion that collaborative joint R&D efforts between competitors or potential competitors is something to be concerned about rather than something to be celebrated and supported. So turning to the merger control rules, how am I doing for time? Competition authorities in the EU, the US, the UK are taking a much tougher stance on pharma and tech transactions, alleging that markets have become too concentrated, prices are too high, new entrants are foreclosed. They've been pushing notions of killer acquisitions, nascent competition, and other theories of innovation harms, alleging that big pharma and big tech are unfairly buying up promising startups, either to kill off a threat to one of their blockbusters or to bring in-house new technologies that allows them to abandon their own less successful R&D efforts. Now, it's uncontroversial that innovation is a key parameter of competition and a valid criterion in the Commission's merger appraisals. And the Commission has traditionally focused on market-to-pipeline or pipeline-to-pipeline overlaps. But in the Dow DuPont decision in 2017, for the first time, the Commission applied the unilateral effects model used to assess pricing effects and applied it to the assessment of innovation competition. And in doing so, it went beyond looking at pipeline products and sought to assess harm on innovation incentives in innovation spaces that, by the Commission's own admission, do not constitute markets. It relied on a mix of indicators, including the merging parties' relative R&D spend, R&D headcount, sophistication of facilities, citation-weighted patent shares, internal documents, et cetera, sort of harking back to some of the criteria that the Commission is building into the R&D block exemption criteria. Much ink has been spilled on Dow DuPont, and I'm not going to rehash that debate here, beyond noting that subsequent to that controversial decision, the Commission did go to some pains to point out that there is no economic or legal presumption that mergers necessarily reduce innovation. Some economists at the time argued for a more cautious and balanced approach, since the link between competition and innovation is much less direct than the link between concentration and static unilateral price effects. And thankfully, the Dow DuPont approach has not been widely replicated in subsequent cases. In more recent pharma decisions, such as BMS Celgene and AbbVie Allergan, the Commission sensibly did not identify any specific harm to overall levels of innovation, given the large number of R&D organizations competing at global levels in fields such as autoimmune disease, fibrotic diseases, oncology, etc. And it declined to look in depth at overlap products at early stages of development because there were a sufficient number of potential competitors, and recognizing that those early stage development projects were many years away from a hypothetical and highly uncertain market launch. But in more recent years, the debate has transmogrified into theories surrounding so-called killer acquisitions, transactions that have as their object or effect the discontinuation of overlapping R&D projects. So, the debate on killer acquisitions, there's been a lot of economic literature on this. It spawned a whole new lexicon of hard killers, soft killers, reverse killers, nascent acquisitions, and if you want a definition for those concepts, you can have a look at the article I wrote on killer acquisitions that was published in GCR about a year ago. But quite a lot of commentators are making the point that whilst killer acquisitions are a valid concern, their likely prevalence in the real world does not justify over-enforcement or changes to the law. The debate is part of a much broader trend reflecting political concerns that lax merger control over the last 20 years has facilitated rising profits and increased market power that is correlated with an alleged decline in market dynamism. And that in turn has led to, for example, the adoption of lower intervention thresholds in Germany and Austria with the deal value thresholds. And if you look at how those deal value thresholds that have been in place since 2017 operate in practice, they've triggered a handful of notifications annually, but they haven't as yet unearthed one single instance of a killer acquisition to my knowledge. That hasn't stopped the new Turkish law coming into force in May 2022, which catches all deals involving technology companies, very broadly defined under the merger rules, where the worldwide revenues of any party to the transaction exceeds $190 million US, another layer of regulatory overload. The Commission has recently awarded our hosts, Lear, to carry out a study on killer acquisitions in the pharmaceutical sector in particular, to be completed by 2023. And I'm very much hoping that that study will be sufficiently robust to provide a reliable measure of the prevalence of this phenomenon so that any regulatory response is appropriately calibrated and proportionate. Again, I think it's completely legitimate for competition authorities to preserve the potential for innovation in keeping markets contestable when reviewing acquisitions. But the political debate about high prices of medicines and other market failures conflates different issues and doesn't justify a radical departure from current merger control enforcement standards. I think the recent literature on macroeconomic concentration levels is of little relevance to the pharmaceutical sector, which is characterized by a large number of R&D organizations competing globally in dynamic early-stage innovation. And second-guessing investments in early-stage innovation invites errors and may lead to suboptimal resource allocation, not least given the myriad very difficult, complex scientific and commercial decisions that influence whether or not companies continue high-risk investments. It's interesting that the most controversial merger control case for the moment and in recent times raises innovation concerns in a vertical integration case. That's the famous Illumina Grail case that has resulted in an overhaul of the EU merger rules on referral. And with a recent General Court judgment in July of this year, endorsing the Commission's ability to exert jurisdiction over transactions that don't satisfy the thresholds at EU level or at any national level, I think the General Court has effectively validated a hybrid ex-ante, ex-post merger control regime that is focused on the competitive potential of tech and pharma innovators, even if those companies have not yet finalized, let alone commercialized, the results of their innovation. There's a separate session on killer acquisitions later today that I'm going to be at, so I'm not going to say more on that at this stage, other than to express a hope that future Article 22 intervention will remain the exception and not the rule. So to wrap up, I mentioned regulatory overlayering earlier. I think the block exemption regulation threatens to become even more unwieldy, even more unuseful than it already is. I think it's threatening to become unfit for purpose. I think that deep-rooted suspicions about harm to innovation, coupled with agency, proactive scouring of industry press to identify potentially problematic deals that are not being notified, burgeoning foreign investment regimes, the prospect of a third layer of regulatory clearance when the EU foreign subsidies regime comes into place next year means that the regulatory environment for transactions is becoming significantly more challenging than at any point in the past. Novel theories of harm based on low-bar presumptions, reduced thresholds, or reversals of the burden of proof would increase transaction costs and have chilling effects without improving consumer welfare. The scale of the challenges that our economies are facing and the sheer dynamism of innovation and scientific and technological development that we're seeing are such that competition authorities should tread very carefully. Let's not upset the balance of incentives that encourage high-risk investments into the new innovations on which we all increasingly depend. And I would argue that from a competition policy perspective, we need a fundamental change of mindset. We need clear and simple rules that encourage and unleash the powers of innovation and that clearly call out and capture problematic conduct. We need to be conscious of the cumulative cost of all of our rules, however well-intentioned. And with that, I'll say thank you and open the floor to discussion.
On innovation side and valuing the positive side the same way that they put the emphasis on the negative side? And maybe in that same sense, do you see kind of also long-term innovation aspects versus only short-term innovation aspects, looking at a static situation rather than looking at a sustainable competitive innovation?
Tough questions. Thanks, Grania. On efficiencies, I think I don't need to tell this audience that we still don't have a decent case where the case has turned on efficiencies. So, I think that really is an area that requires a lot more discussion. I think surreptitiously at the front end of the analysis, if there is a good efficiencies argument, it is taken into account in a sort of overall, how far are we going to push the investigation? Does it tip into phase 2 or not, perhaps? But it's never made explicit. And I do think the way the law is articulated at the moment and then the lack of case law, that remains an important and troubling imbalance. On the long-term, mid-term, short-term, long-term innovation incentives, how far to go, I think that's a topic for discussion, and I'm hoping the reflection that's ongoing and the very open policy debate with some of these studies that are ongoing, that is a debate that happens. I don't have the right answer, but, I think as a citizen, not as an expert or a competition lawyer. Our societies at all levels are facing some massive challenges, and we're going to need a massive change, step change in collaboration to tackle those challenges in the short, medium, and long term, and we've got to take that longer view. And we're still too wedded to the archaic approach of blacklists and whitelists. And, I haven't talked about public-private partnerships. I don't know enough of them to talk about it in any detail. But we're going to need different ways of innovating at scale as a matter of urgency to solve those problems that we know we're facing today and in 10 years' time and in 20 and 30 years' time. I'm seeing some heads nod, so please do feel free to speak up and contribute to the discussion. Yes, there's a question at the back.
Thank you very much. You talked about regulatory overlayering, and I just want to echo that. I think I also have a real concern that we have too much regulation trying to regulate the same thing and the same problem. How can we overcome that? Are we all working too much in silos? Are we listening to the industry enough? And I don't always mean the really large industry or the large industry players. Are we listening to young and emerging companies enough and their founders and what they are going through? Do they have time and resources to talk to us in the regulatory space? But fundamental question is, do you have any thoughts and solutions how we can overcome the problem that we are operating and regulating in silos, but the world is one thing, and for instance, the question whether to make an investment or not is one decision to make?
I think that's the million-dollar question, and I'm just a poor competition lawyer, so I'm actually, I've been in Brussels for 30 years, much as I hate to admit it, and I entered the community straight out of the College of Europe when Margaret Thatcher had just signed the Single European Act, which dates me. That was a massive legislative effort, which, kept a lot of us in employment in those days. But the scale of change that I'm seeing today is a multitude more important than the Internal Market Single European Act. And I think it's really well-intentioned, and I think it's really important, and I personally am very glad to see Europe reacting to the various external crises that we're seeing and stepping up on the geopolitical front to set standards at a global level. But I have to say, I am really worried, and I'm slightly outside of my comfort zone in just sort of how industry is supposed to absorb this tsunami of change that's coming. Working with some of my colleagues from different practice areas in Baker McKenzie, looking at the EU taxonomy regulation and the Corporate Sustainability Reporting Directive and the new Corporate Sustainability Due Diligence Directive that's coming. And I don't know how big, sophisticated multinationals are going to cope with this, let alone a mid-sized German industrial, let alone something, the foreign subsidies regime that I mentioned, a case in point. So it's well-intentioned, we need to act, but it is siloed. I think stakeholders do have a voice. Some are better funded than others. But I think it, at least in the Brussels bubble, gets into expert silos quite quickly. And at a political level, I am not seeing anybody sort of step back and go, despite all of these laudable aims right across the board, are we regulating in a way that is not actually putting us at a global competitive disadvantage, ultimately? I really worry about that, but I certainly don't have the answer. So on that uplifting note, maybe we'll draw this session to a close. Thank you very much for coming. Thank you.